After witnessing how hard the Trump administration went after Harvard, Columbia, and other universities, I'm surprised we even have this question before the California court. But here's the question. Can a California university refuse to hire undocumented students who lack federal authorization to work in the United States? Now, the universities argue that they don't want to be prosecuted, they don't want to be liable financially, and simply they don't want to be pushing federal buttons to figure out if they're violating federal law. But the answer to this question will surprise you. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, welcome. Hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com, where you'll find a bunch of different merch, including these Do Not Arrest This Person t-shirts, stickers, pins, and other items. And this week, if you put in a promo code NOTGUILTY, you'll receive 10% off. Thanks for watching, and let's move on.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we're discussing a California appellate decision, Jeffrey Umania Muñoz versus the Regents of the University of California. Now, the University of California has an employment policy which prohibits employment of undocumented students who lack federal authorization to work in the United States. Now, Mr. Umania Muñoz and other students challenge this policy and argue, amongst other things, that the university's policy is unlawful because it discriminates in violation of the Fair Employment and Housing Act, and specifically sections 11,028, subdivision F3 of Title II of the California Code of Regulations, which provides that it is unlawful practice for an employer or other covered entity to discriminate against an employee because of employees' or applicants' immigration status, unless the employer has shown by clear and convincing evidence that it is required to do so in order to comply with federal immigration law. Now, according to the university, thousands of undocumented students attend their campuses every year. And for a long time, University of California tried to accommodate and provide employment to some of those students. For example, recipients of DACA, because after all, those students sometimes were able to obtain temporary work permits. But in 2018, the federal government essentially eliminated DACA and no longer accepted new applicants. Since then, the University of California reevaluated its own employment policy and no longer provided employment to undocumented students. Now remember, under the Fair Employment and Housing Act, the entity can show that they're required under federal law not to provide employment. But that's not exactly what the university here said. Instead, they were balancing the risks involved in providing employment to the students. The university has expressly taken no position on whether its policy is required by federal law. Rather, it argues that its policy does not discriminate based on immigration status, and that even if it did, decisions regarding the policy are vested in its sound discretion. And the continued use of the policy is supported by its analysis of the risks to the university and its students and employees if it hires undocumented students without federal work authorization, including the significant risk that the federal government will read the Immigration Reform and Control Act of 1986 to apply to the university and initiate enforcement action, and a federal court may agree. The state appellate court says that the university's policy is clearly discriminatory based on immigration status. And under Fair Employment and Housing Act, you can't do that unless the federal government mandates it. And the court says that it is not clear and there's no precedent that IRCA, the Immigration Reform and Control Act, even applies to universities. The state court says that the fear of penalties and lawsuits is not a justification to violate state law. And so this means that the policy is illegal under Fair Employment and Housing Act. And so what can the universities do now? Of course, they can appeal and try to get to the Supreme Court. They can also try to get the legislature to rewrite the law, meaning the state system, say that under Fair Employment and Housing Act, the universities do not have to employ individuals who don't have a legal right to work in the United States. And in the meantime, the university can, of course, change their own policy and begin employing undocumented students. So here's a question to you. In the comments below, tell me your opinion about this case. What should the University of California do? Should they employ undocumented students? Should they try to get to the Supreme Court? What is next to them? And what's your opinion here? If you enjoyed this video, give it a thumbs up. Again, if you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And this week, if you put a promo code NOTGUILTY, you will receive 10% off. I will see you next week for another deep dive on another case. Thanks for watching.